We are here in the matter of Yokita McCoy versus Kean Hill, case number 24-11609PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today for trial on the allegation that Mr. Hill carried a firearm in violation of the court's protective order. So at this time, Ms. McNabb, will you place your appearance on the record?
Thank you, Your Honor. Lauren McNabb, Assistant Prosecuting Attorney for Ms. McCoy.
Very good. And Mr. Hill, would you please state and spell your full name for the record?
Kean Hill.
Can you spell that, please, Mr. Hill?
Keon. Deshaun, Deshaun, Hill, Hill.
Thank you, sir. And Ms. McNabb, you may proceed.
Thank you, Your Honor. I'd like to call Ms. Yokita McCoy.
Very well.
Yes.
Ms. McCoy, would you raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
Very good. You may proceed, Ms. McNabb.
Thank you. Ms. McCoy, could you please state your full name for the record?
Yokita McCoy, or first middle name, or just my first and last?
First and last is fine. Thank you.
Yokita McCoy.
Okay. And Ms. McCoy, how do you know Mr. Hill?
He's the father of my granddaughter.
Okay. And did you seek a personal protection order against Mr. Hill?
Yes.
Okay. Do you remember roughly when that was?
If I'm not mistaken, had it been November. Had it been November, I can give exact date.
Okay. And to your knowledge, is that PPO good till May?
Correct. Yes.
Okay. Your Honor, I'd like the court to take judicial notice of the fact that the PPO was granted on November 21st of 2024. It expires May 21st of 2025, and it was served on Mr. Hill on December 25th of 2024.
Very well. The court will take judicial notice.
Thank you. And Ms. McCoy, were you present when it is alleged that Mr. Hill had a firearm?
No, he was at Akaya's father and stepmother's house.
Okay. And besides this incident, have there been anything that concerns you since the PPO has been granted in terms of contact with you, or something made you afraid?
When the PPO was first granted, when it was granted, it continued. I try to warn Kean plenty of times, like, whatever it may be, just please stop. He kept harassing me. I let them know that I got the PPO order and it will be in effect, and I'll have it delivered, try to get delivered, everything. I'll let him know plenty of times. But he continued to harass me out, with that there. That's why December 25th, he was harassing me that day of Christmas. And that's how the police was able to serve him, because he came to my house, to my complex, as I was going to get coffee. He had let my daughter know for me to come outside. He had a gun, and that's how he even got arrested. But it continued to went on from there. Then just so happened, after that happened, I can say it continued for a while. When I say it continued, when the internet, the string on the family, it got terrible. Until I had to ask Akaya to move her from my home, to go stay with her father, because it was causing too much. And then that's how it kind of died down until when she left, it kind of went with her. As long as he had her, I had no problem.
All right. Thank you very much, Your Honor. I have no further questions for this witness.
Mr. Hill, do you have any questions for Ms. Yokita McCoy?
No, Your Honor.
Very well, then, Ms. McCoy, you may step down from the witness stand. Any additional witnesses at this time, Ms. McNabb?
Sorry, Your Honor, my phone just started going off, and it's on my computer, so it was a little disconcerting. Yes, I'd like to call Ms. Yokita McCoy.
Very well, let's bring her in. Or she's here.
Yeah. 1 second, we're gonna move with it, okay?
Miss Yokita McCoy, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
Thank you. You may lower your hand. And Miss McNabb, you may inquire.
Thank you. Ms. McCoy, could you please state your full name for the
Yokita McCoy.
Yokita McCoy? Okay. And Ms. McCoy, how do you know the petitioner in this case?
Oh, that's my mom. I'm sorry.
Okay, that's okay. It's a kind of a weird way to ask the question. So Ms. McCoy, on this day, we are interested in what happened on January 9th of 2025. Do you remember that date?
Yeah.
Okay. And can you just describe what happened on that day in your own words?
Are you saying, okay, Jerry, like the day he got arrested, correct?
Yes, I believe that is how the day ended. Yes.
Yeah. To sum it up, basically we had gone to an argument or whatever. And yeah, we had gone to it. And Kean, I don't know what point y'all trying to get to, if y'all
Okay.
rather act. But
Okay,
it was
yeah.
an argument.
Okay, apologies. Let me maybe be a little bit more specific. On that date, were you were present with Mr. Hill?
Yes.
Okay. And does Mr. Hill have anything on his person?
Say it again, it broke up.
Sorry, did Mr. Hill, was he carrying anything?
Yeah,
What was he carrying?
a firearm.
Okay, can you describe the firearm?
It was just black.
Black. Okay, was it a pistol, a shotgun, or?
Most likely, yeah, a pistol, handgun.
Okay, and do you recall where he was carrying that gun?
In his pocket.
Okay. Is there anything else you think the court should know about that day?
Not that I know of, besides like, what's on paper,
Right. All right. Thank you, Your Honor. I have no further questions.
And I don't have any additional questions for Miss McCoy either. Do you have any questions, Mr. Hill, for Miss McCoy?
No, Your Honor.
Okay.
Very good. Then you may step down, Miss Yokita McCoy, from the witness stand. Any other additional witnesses or evidence to present, Miss McNabb?
Thank you, Your Honor. I'd like to call Officer DeVore, who I believe Lisa has or Miss Baird has in the waiting room.
Okay. And Officer DeVore, if you're able to unmute, I'll swear you in and then we can take your testimony.
Should be unmuted.
Yep, that's great. Would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
You may proceed, Ms. McNabb.
Thank you, Your Honor. Officer, could you please state your name for the record?
DeVore, Officer Samuel DeVore.
Thank you. And Officer DeVore, how are you employed?
I am a member of the Grand Rapids Police Department.
And how long have you been a member of the department?
I've been on patrol since approximately February of last year.
So February 2024?
Yes.
Okay. And on today, we're concerned with the happenings of January 9th of 2025. Do you recall that day?
I believe I do, yes.
Okay. And a specific call regarding Mr. Kean Hill and Ms. McCoy. So what do you remember?
It's been a long time since the incident. I couldn't tell you anything specific about it at the moment. I apologize. I'm just coming from another call, and I was trying to look over the report before I got back to it.
Oh, that's okay. So is there something that would refresh your memory?
Yes, if I could look at the report.
Your Honor, I'd like to ask that he be allowed to look at the report to refresh his memory of the incident.
That is permitted.
Thank you.
Yes, I remember the incident well.
Okay. Thank you. So can you describe what happened?
We were originally called for service for some sort of a domestic incident, and told that there may be a PPO in place. I then made contact with the victim on the front porch, who we initially believed was the protected party of the PPO. It was not the protected party of the PPO. She advised that the suspect was inside, armed with a firearm, and was unclear about whether or not she had been assaulted. Initially, we pulled everybody out of the house. We also found warrants for the suspect, so we then made a perimeter around the house, gave a long series of commands consistent with our emergency situation protocol. The suspect eventually was arrested by our SWAT team and was placed in my car for transport. I spoke with him after reading his Miranda rights, and a firearm was ultimately found inside of the home. I consulted with my sergeant prior to writing any charges, and I believe he was charged with CCW, resisting and obstructing an officer, and a violation of his PPO, which included that he should not be armed with any firearms or in possession of any firearms, along with the original warrants.
Okay. And how did you locate that firearm? Did someone just come across it, or?
Based on a consent search of the home and based on his specific description of the location where the firearm would be post Miranda advisement.
Okay. So Mr. Hill told you where you could find the firearm.
Yes.
Okay. Thank you. And was there a chance that it was somebody else's in the home?
The owner of the home and all occupants of the home advised that no one in there had a firearm and there should be no firearms in the home.
Okay. Thank you. I have no further questions.
Mr. Hill, do you have any questions for Officer DeVore?
No, Your Honor.
And I do not have any questions for the officer either at this time.
All right. Thank you. Your Honor, may this witness be excused.
Officer DeVore may be excused.
Thank you.
Thank you, Your Honor. I apologize for being late.
No worries.
All right. And Your Honor, I have no further witnesses or proofs.
Very good. Do you have any witnesses or proofs that you wish to present, Mr. Hill?
No, Your Honor.
Then I believe we're to the time for a closing statement, Ms. McNabb.
Thank you, Your Honor. I believe we've proved well beyond a reasonable doubt that Mr. Hill was in possession of a firearm on January 9th of 2025 in direct violation of this court's PPO order. So we would ask that you find him to be in violation and contempt of court and judge him responsible. Thank you.
Very good. Mr. Hill, anything you'd like to say by way of closing argument?
No, Your Honor.
All right. Well, the question before the court is, did Mr. Hill carry a firearm on the date of this incident and thereby violate the court's protective order? And the burden of proof on the prosecution is beyond a reasonable doubt. And the prosecution has presented three witnesses today, one of which, Ms. Yokita Hill, who is the petitioner, but was not present during this particular incident. And then also Yokita McCoy, and I'm sorry, that's Yokita McCoy was the petitioner, and her daughter, Yokita McCoy, was involved in the incident. Both Yokita McCoy and Officer DeVore testified that Mr. Hill was carrying a handgun on the date of the incident, and that is on or about January 9th of this year. So I will find Mr. Hill in contempt of court. At this time, we can move immediately to the sentencing portion. Anything additional by way of sentencing, Ms. McNabb?
Yes, thank you, Your Honor. I've spoken with Ms. McCoy, and this incident has been extremely frightening, especially as a continuation of the past incidents that led her up to getting the PPO in the first place. Knowing that Mr. Hill was walking around with a gun in defiance of the court's order has been very, very, very upsetting. And, we would ask for at least some jail time to impress upon him the serious nature of these orders and of this specific violation.
Okay, very good. And do you have any information as to the following follow-on charges of CCW and the warrants?
I believe, let me pull up those notes, that Mr. Hill pled to stalking and interfering with electronic communications, and then was referred to the domestic violence court. And if he completes the domestic violence court successfully, then domestic violence deferred and attempted electronic communications charge with HIDA at judge's discretion.
Okay, very good. Thank you. Mr. Hill, anything you would like to say before I impose sentence?
No, Your Honor.
And I guess Ms. McCoy is and that'd be Yokita McCoy as the victim, has an opportunity to speak as well. Anything you'd like to say, Ms. Yokita McCoy?
I'm sorry. Unfortunately not. But just thank you. For nothing, I have nothing to say.
Very good. Thank you. Mr. Hill, can you tell me where you are in the domestic violence court program right now?
I'm on the first stage right now. When I had just got out on the 16th, I had a report back there the next day, and they told me that I'm in the first stage right now, where I gotta go through a whole bunch of evaluations, and then just some drug group that I gotta do too, to drug assessments, all that she said.
Okay. Yeah, they're putting you through a lot of work. Well, I'll tell you what I'm going to do is I don't want to, you frankly, because of the seriousness of the violation here and the weapon, an argument can be made that you deserve some jail time. However, I'm going to hold off on that. I'm going to suspend some jail time right now and just give you a fine. It'll be for the violation of contempt of court. I'll find you that you have violated. I'll impose a $200 fine and also 30-day jail sentence suspended. However, that's contingent on a couple of things, Mr. Hill. That is no ongoing violations, and also that you continue to successfully participate in that domestic violence court. If you get booted out of that thing and those charges kick in, I'm not going to have any reason to hold off on giving you the 30 extra days in jail as well. So I just want to put an exclamation point on the importance of you doing that process in DV court. I preside over a specialty court myself, the treatment and support court for felonies here in the circuit court. And I can tell you the front end of that looks like a lot of work. You got a lot of evaluations, new meetings, counseling appointments, things like that to set up. However, there is, as I tell all my people in that court, there is a method to it. There's a reason that you go through that process, and that is to point out, the issues that you need to work on. And as you focus on those, it gets easier. In other words, you get into a routine of making the appointments and meetings that you need. They get to be more regular, and you complete it. And I'm very confident that when you complete this, if you're successful at it and you take the information to heart, just go through the motions, you're not going to have these issues again, because at the end of it, it looks like it was a confrontation, a domestic violence type thing that led to the PPO in the first place, and then to this run-in with Mr. Kean McCoy in the second place. So it'll allow you to understand how that dynamic works out, and the red flags you need to avoid to avoid further incidents of domestic violence in those cases. Is there currently a no contact in place with you and Mr. Kean McCoy?
Yeah.
Okay, and that's through the probably part of your bond conditions to get you into domestic violence court. Obviously, you need to carefully observe, that no contact order as well. I know you share a child together. However, it doesn't mean you can never have any contact or relationship with a child. It just simply means you need to get this domestic violence stuff sorted, so that then you can be the, dad and male figure in your child's life in the future. Rather than a scenario where you're in and out of jail and, that's your child's memory of you. It's trying to put you on a path where, you can have a responsible relationship with your child and ultimately perhaps with Miss Yokita McCoy as well, although that's ultimately up to the two of you. But for the time being, observe that no contact order. Do what you need to do in that DV court. It's a brand new program, and it's, as far as I can tell, an excellent program. And you'll avoid jail time. However, if you screw up, I won't hesitate to throw you in jail. And with that, we are concluded. Thank you.
Thank you.
We are here in the matter of Amanda Kinney versus Dakota Rate, case number 23-11502 PP. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter was scheduled for trial today following a not guilty plea to certain violations alleged to have occurred on or about let's see here. Looks like in November 12th of 2024. Counsel, would you please put your appearances on the record?
Thank you, Your Honor. Lauren McNabb, APA Kent County, for petitioner Ms. Kinney.
Very good.
Ryan Mason on behalf of the defendant, Dakota Rate.
Very good. Thank you, Mr. Mason. And I see Mr. Rate present beside you, Mr. Mason.
That's correct. He's right here to my right.
Mr. Rate, would you raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do, Your Honor.
Very good. And Mr. Rate, is it correct that you're willing to plead guilty to violation of the protective order at this time?
Yes.
And has anyone offered you anything in exchange for your guilty plea today?
No.
Anyone threatened you to get you to plead guilty?
Nope.
So this is your own choice?
Yes, it is.
And what you're pleading guilty to today is on or about November 12th of last year, you attempted to make contact by phone with petitioner Amanda Kinney.
Yes, I did.
All right, very good. I'll accept the guilty plea, finding it voluntary, supported by an accurate factual basis. We can move directly to sentencing. Anything by way of elocution, Mr. Mason?
I think we already went over this, but just to make sure it's on the record, this is, I believe, his third violation on two different PPOs over a year. This did occur almost 6 months ago. Since that time, he did plead guilty to stalking in Wyoming. He's on, I think, 5 years probation there. As far as I know, there's been no violations. I do think that the court should be aware this was driven by a problem with alcohol. He is working really hard to keep that under control. He's in counseling and therapy for that. I do believe that drove the poor judgment here to contact her. And I feel confident if he's able to maintain his sobriety, he's very unlikely to have any contact with her ever again.
Very good. Thank you. Any statement from the prosecutor's office or the victim, Ms. Kinney, at this time?
From me, Your Honor, just stating that this is the third violation we've come before you on. I believe the first one you gave Mr. Rate 30 days suspended. The second one you imposed 15 of those suspended days. So as much as I would like to share in the hope that this is going to be over, I express some hesitancy and would ask that you continue to escalate the punishments until Mr. Rate understands.
Thank you. Ms. Kinney, anything from the victim's standpoint?
I appreciate the fact that, the city of Wyoming took it so seriously, and he did plead guilty to stalking and is required to do AA, but that does not take back the fact that this has already happened multiple times. I feel unsafe. I'm out and about. I travel back and forth quite a bit between Holland and Grand Rapids, and I just need this to be over. And obviously the last time that he served 15 days, that wasn't enough to actually get it to stop, and it happened again. So yes, if he can stay sober, will it stop? Maybe. But if he doesn't stay sober and there's no guarantee, then what?
Okay, no, thank you, Ms. Kinney. That's a very valid concern. All right, and Mr. Rate, anything you'd like to say to the court before I impose sentence?
I just kind of, can I briefly say like why I contacted or tried to?
If it is, not advised against, it's your
Well, I
time, do
just-
whatever you want.
It was mainly just, I'd been going to church and really getting God in my life, and I had made a lot of mistakes with her, and she tried to help me a lot when my dad passed away, and I just wasn't a very good person, and I was feeling really down on myself when I called her, and I just wanted her to know I'm sorry for everything that I did, and just we'll leave her alone. So.
All right, well, thank you, Mr. Raitt. You sound sincere about that. Of course, you did sound sincere about it last time when I penalized you for this. And I can tell you from the victim's perspective, from the petitioner's perspective in these cases, you know, that what Ms. Kinney is saying and the prosecutor is saying is they do indeed want these just to be over. They don't necessarily, of course, their feelings about the whole situation change as time passes as well. But when you reinitiate contact and the order's still in place, that would raise the question in any petitioner's head, what's going to happen next? Is he going to escalate? Is he going to try to contact me in person or show up at my house or something? And it kind of starts that cycle of fear and worry and anxiety over again in the petitioner's mind. And of course, the protective order is designed to make that space and create that peace for the petitioner. And that's what you're trying to do here. I commend you for your efforts to stop drinking. Certainly, AA is a great route, and particularly if you're finding a good spiritual home, to do that. AA, does require surrender to a higher power. And that I've seen people make great successes, and sustain 10 or 15 years or more, a lifetime of sobriety in the AA program. So I think that's a great first step. If you find that it's you need extra, there are great other programs out there too, intensive outpatient programs at Arbor Circle or Journeys or Network 180, wherever you might go. They offer programs that can give you some more direction on the feelings that drive, because people turn to substances for a reason. And, some of those emotional things that you've struggled with, the loss of your father and the loss of this relationship, are things that certainly, would be normal things for someone who, kind of self-medicated by drinking. So, and those are important things to address too, as you go along, and AA doesn't necessarily take those things on head on. So I certainly would, if you find you need something to supplement it, go in and get an evaluation at one of those places. Network 180 is our local, in Kent County anyways, our community mental health provider. So that's a good first stop for anyone kind of looking for help. So that'd be my recommendation. The sentence of the court on this violation will be 15 days in jail. I will have you serve that over, I believe you get 3 days credit if you go in on a Friday evening and check out on Sunday for weekends so that you can continue work and also doing AA and your probation requirements, things of that nature. I'll have you report then for 5 weekends to the Kent County Jail. If they cannot accommodate that, then I'll just have you do 15 days in jail with work release. And if weekends cannot be accommodated, then I'll have you start that a week from tomorrow, which would be, I believe that's May the 2nd, to report at 9 a.m. And Mr. Mason, if you would help Mr. Raitt coordinate that to see if those weekends are available or if he should have a report date, that would be helpful for me. I did note that this order does expire on May 22nd of this year. Ms. Kinney, would you like it to be extended at this time?
Yes, please. There's a no contact order, but it would be nice to have both in place.
Yeah, I agree. And in some respects, the protective order is more specific and, and I'll remember this case. And of course, I've been involved with it this long, so I know the history. I'll extend it this time for 1 year until May 22nd of 2026. So just put an exclamation on that point that no contact means no contact. And I think you got that message loud and clear when you're sober, Mr. 8. And boy, I can't tell you how many people I see in court who, whether it's alcohol, drugs, or different substance, they become different people when they're doing that. And so I think you're working down the right track to put this behind you and get on with your life as well. So I appreciate everyone's cooperation today. And with that, we are concluded.
All right, thank you, Your Honor.
Thank you, Your Honor.
We are here in the case of Shelby Pavey versus Christopher Bryant, case number 24-07395-PP. This hearing is being recorded on Zoom and live streamed on YouTube.
And this comes before the court initially. Well, today, was this the date I set? This is the notice of hearing then on the motion to dismiss, and also a violation. Remind me, what am I noticed up on for today?
I was noticed for the hearing, sir. If the court needs time to review that, we can come back on the hearing if they, depending on whatever the people believe. But I also submitted the motion. I presume that somebody would respond to that. Nobody did respond to that, so I don't know exactly where their position is on that as of right now. But I think that needed to be heard prior to what we submitted this under 2 points.
Well, we may be able to-
116 C10 motion.
Okay, I think we may be able to deal with both, Ms. McNabb. What's your position?
Our position is we disagree with the motion to dismiss. It's Mr. Schmeel's motion, so if he would like to make argument that I can respond to, or I can just respond to the motion itself.
And then we're also here on the violation. That is your understanding, Ms. McNabb?
Yes, Your Honor.
Okay. All right. Well, Mr. Schmeel, let's deal with the motion to dismiss initially then. And as I read it, you're saying the specific facts as pled do not rise to the standard required for a violation of the protective order under the Michigan statute.
That is correct, sir. I think the court is absolutely right on what my argument is. And just for a summary of what the alleged facts are, what has been submitted by, I think it's Ms. Pavey, the petitioner in this matter stated on January 16th, I'm going to presume that that's my client, texted my mother and sent a video of a bunch of photos and videos of me in a song. And at the end, it stated, I hope you had the time of your life. I will notice for the court that the Hope You Had the Time of Your Life is a Green Day song, which was submitted. That is the title of the song, which she stated, which is extremely creepy and threatening. I will notice on the personal protection order, there are absolutely no preclusions whatsoever of my client contacting the individual's mother. There's probably some substance in the background of them having contacts before. Obviously, they had numbers and had shared contacts before. They're simply here as far as what's alleged in this affidavit by the petitioner in this matter can't be a violation in and of itself. Now, if my client stated if there was some more documentation there that said my client stated that he needed to contact a third party or instructed her to do so, I see there could be a plausible violation that the people could move forward at that time. As what's stated here as of right now is not sufficient for a violation, to be fair. And the statute is very clear on that. The statute is also very clear is that the PPO provisions have to explicitly state what you may not do. The PPO petition in this matter and the order from the court stating you may not enter in the property, you may not have a discussion with this individual, has nothing about the recipient of this. Say it's a brief documentary of videos, or excuse me, photos.
I want to pause you because I did, and this is a relationship PPO, which I do issue fairly frequently. And this particular one in paragraph 6 does reference stalking as defined under 750.411H and I, which are the electronic stalking provisions of Michigan law. And I will note and have noted for many respondents here that those are significantly broader in their scope than the specific prohibitions listed below, and that you could say, well, I didn't do, a direct contact or send email or other communications. And I guess those go under the other communications rubric of the language of the PPO, but they are significantly broader and include that scenario where, you send someone something electronically, with intent or knowledge that they're going to pass that on or post it where it's going to be visible to someone else, sort of that cyber stalking type of conduct. But at least that's how I have interpreted these now. I have read the statute in the past. I don't have it in front of me right now, but I know it is significantly broader than the language of the PPO itself. It does put a burden on the respondent saying, boy, if I'm going to do anything here, maybe I ought to review these two statutes. That is a lot to ask, but we ask that, of course, of people, subject to court orders all the time. So what's your response, Ms. McNabb, to the argument?
Thank you, Your Honor. You summed it up at least a little bit. The PPO specifically in paragraph 6 prohibits the respondent from stalking as defined under MCL 750.411H and MCL 750.411I, and that includes but is not limited to. And then if we go to the statute itself, 411H, stalking is defined under section E. It means a willful course of conduct involving repeated or continuing harassment of another individual that would cause a reasonable person to feel terrorized, frightened, intimidated, threatened, harassed, or molested, and that actually caused the victim to feel terrorized, frightened, intimidated, threatened, harassed, or molested. And because of that definition, and I'm not going to bore you with doing the same, it's the same definition in 750.411I. But the main point is there is a question of fact that is appropriate to be heard by the trier of fact as to whether or not this action constituted harassment. I will note as well, the court has recognized in the past contact through a third party as contact, most notably for Court of Appeals. That would be case TT versus KL.
I'm going to object to all of this quotation, because if the people, they got my motion March 18th, and I forwarded on to Mrs. McNabb. So she's going to be quoting a bunch of stuff that we don't have not looked at. There is a whole lot, and I mean an extraordinary lot of case law regarding stalking in of itself. So if their response is going to be stalking, and this can comport stalking, he's charged with stalking. And then we also have a double jeopardy United States v. Dixon issue. There's a whole bunch of stuff. So if they're going to do that, they need to put it in writing.
People v. Coons, which is specifically found that the Michigan stalking statute and the PPO statute are not in conflict, and it's not considered double jeopardy.
People v. Coons is, you're missing what's going on there. And United States v. Dixon states it is. And that's a United States Supreme Court case with the author being Judge Scalia, and that is binding.
All right. Well, in any case, I think I can decide this based on the statutory language and my familiarity with it. And there, just to clarify, there's not a stalking charge pending here on top of the PPO violation. There is one here?
There is. That's why I'm saying, if they're going to be saying that, there is an absolute double jeopardy issue, and it is binding on the court of what they're going for. So we have to look at what the actual contacts were, if there's two or more contacts, if there's a continuity of contacting the individual. This is not contacting an individual. Now, like I stated when I first started here, if my client instructed a third party to have contact with the individual, then they can do that. Then there is absolutely something under the stalking. You can't just say, well, you can't contact anybody. Because if, say this, for example, what if there was somebody, you're mutual friends with someone, and you say, she did this, she did this, she did this, and you're just confiding in somebody, that person then relays the message that violates a PPO. That's not what PPOs are meant for.
You just predicted my next case that's up this afternoon, Mr. Schmiel. But in response to that, we get that sort of thing all the time. And you're right, it is, at the end of the day, it's a factual examination of the case. And I think that, based on what I've heard here, what I'm going to do for the moment is I'm going to deny the motion to dismiss the violation. We'll keep it pending. However, I don't think that proceeding factually makes any sense if we've got a pending stalking charge on the same conduct. Is that correct, Ms. McNabb, or is it different conduct?
I believe this conduct is one incident, but I believe this incident is part of that stalking charge.
Yeah, and I guess my thinking would be, because obviously the criminal law violations potentially more serious than the finding of criminal contempt in violation of a civil protective order. The usual of what I do there is I hold off on adjudicating the civil protective order until there's some resolution in the criminal court. Does that seem to be the right course of action here?
If that's what your honor would like
Yeah,
to
I guess
do.
similar to, for example, a probation violation involving, allegations of new criminal conduct. It doesn't make much sense to me to take record evidence in a case like this. Although the standard of proof is beyond a reasonable doubt, it's essentially the same. But I think that for both sides, for your prosecutor's side, it raises the question of double jeopardy on this and any related contact. It can be tied back to this particular incident. And then, of course, the issue for Mr. Schmeel's client is if he testifies here in court and locks himself in on testimony that's of record, that certainly can be used to his detriment in the criminal proceedings where, the risk may be significantly higher for him. So absent a resolution of that, I will adjourn the factual hearing today until we have a more clarity on what's going to happen in the criminal matter.
All right, and your honor, just for the court's knowledge, then I'm looking at the stalking case. It looks like the next hearing would be on May 5th, and then there's a jury trial set after that on May 13th.
So it's not going to be a tremendous amount of time to wait and obtain some sort of resolution.
Unlikely, your honor.
Okay. And Mr. Schmeel, are you also representing respondent in that criminal matter?
No, I have spoken with his attorney though. It is Miss Madeline from the Kent County Public Defender's Office on that case.
Okay.
I've looked at that in privity and pulled up police reports on that, but I don't. The short, sorry, Your Honor. I don't represent him on that case.
Okay. All right. Very good. Well, as long as you're communicating back and forth, and we know what we'll do is we'll set another hearing for this after the date of the trial in that case. Lisa, can we give that date at this time or?
I can. We could do be Thursday, May 22nd at 2:00.
I'm sorry, that broke up a little bit on my end. I apologize. My internet's probably not the greatest. Did you say May 22nd?
Yes, at 2:00.
Okay.
Very well. And my understanding, I believe this protective order remains in place, and I would suspect because there's a stalking case, there's a no contact order. So I would obviously caution respondent to avoid any contact in the meantime.
Lisa, did you say in person or Zoom for that? I apologize.
Oh, did you want that in person, Marcus?
I think, and I'll leave it up to the court's discretion. I wasn't aware, Your Honor, and I apologize. The only ones of these I've done have always been in person. I believe that the evidence that's been submitted to me by Ms. McNabb calls for probably 106 issues, foundation issues, and a bunch of other things, which Ms. Pavey is going to have to obviously put forward to the court. It doesn't seem like it's going to be a feasible option if they're going to be admitting evidence to do this over Zoom. If that's a problem for the parties, I'll absolutely understand that. I just think it would be a lot more succinct doing that. So I will leave that up to the court's discretion.
Some of our technology experts, which I believe include Ms. McNabb, are able to display and place exhibits on the record, screen sharing them on Zoom. And I'm comfortable doing it either way. What are your thoughts, Ms. McNabb, person or on Zoom?
I have no objection to either way, Your Honor. I would agree with Mr. Schmel that it's probably a little bit easier to put exhibits on the record in court and to have everybody look at them, but.
Then let's hold it in person.
Okay.
That's fine. And I'm sorry, I need to correct the time to 2:30, please.
Thank you, ma'am.
May 22nd, 2:30 p.m.
Yes, sir. And just so we're clear on the double jeopardy issue for where I stand on this and why it's different from the Coons case and the Dixon case, you have to look at the kind of contempt that it is. There's two different kinds of contempt, and that's the succinct part of what's issued here. People v. Coons is a case that's decided on contempt that happens directly before the court where someone's not entitled to a hearing, and therefore it's not beyond a reasonable doubt. It's a completely different circumstances to where they go. I've read that case too, and it had me very confused for a long time. Then reading the Dixon case, the difference there is the type of contempt. The Michigan statute actually bifurcates both of those and dictates how those have to be handled. For example, if I was in your court, Your Honor, and yelled out some pejoratives, you could immediately throw me a contempt for that. I would not be entitled to a hearing. However, if that happens outside the scope of the court, then that entitles the individual to a hearing, which is beyond a reasonable doubt. It is, in fact, almost analogous to a criminal matter. And that's what Dixon has decided on.
Okay, yeah, no, and that's how I generally find the contempt standard, you know, and right, and I haven't ever had a case where there's been direct contempt in the courtroom and I've immediately jailed either a defendant or an attorney. Though I've heard of it in legend, such things have happened. It's not happened in my courtroom. I decided virtually all of these after a hearing and apply the beyond a reasonable doubt standard. And I will clarify for your purposes, what I denied today was your motion based on the specific facts not fulfilling the stalking statute. I think you do preserve your double jeopardy argument for after, you know, I mean, for example, if he is found guilty and sentenced in the criminal case, then I think you've preserved your double jeopardy argument for after that he's already been punished and that he can't be punished twice for the same conduct.
Thank you, sir. And I'm gonna, if the court doesn't mind, I'll look into that. And if there's a deemable appropriateness where I'm gonna default to what the court's saying as far as the stalking statute. I know that there's a lot, I've litigated these, to be fair. In misdemeanor cases, stalking gets very specific on actual stuff that's going on in those cases. Would the court mind a supplementary brief if in fact there's some case law that determines that there's a difference from what the court ruled?
You're welcome to submit it on reconsideration.
Okay.
Haven't granted one of those in a while, but that doesn't mean I never will. So
Thank you, sir.
thank you.
Have a good afternoon all.
You as well.
Yep, you as well.